Okay. Are there issues that are facing your division that are looming on the horizon? That
not really. Issues. There's a. I think, if I may, I have to give you a little history so that you understand how the law has changed in my lifetime. When I started practicing in 1963, we didn't have a set of trial rules that were passed around 1970, about the time our court came into existence. And so when the trial rules came out, there were definite rules to guide lawyers on what they do, and the pleadings changed. My kid's great-grandfather, my two sons' great-grandfather, was a lawyer in Linton, Indiana, and when he died, as a sole practitioner, I took possession of a lot of his old law books, so they look nice in my law office because they're leather bound. He probably got them for $1.25 back in the days he practiced. But I pulled out the other day a book on civil procedure dated 1910, and realized that the same rules and pleadings outlined there they were still doing in the 60s when I became a lawyer. So a lot has changed. What happened was that the rules changed it so there's no surprises. In other words, the real trials, as opposed to what we see on TV, there's no surprise witnesses. You have to list all your witnesses. You have to reveal your exhibits. So that's changed. In my years on the bench, when I first became a judge in 1999, the civil judges got together and decided that we would change a few things. And one of the things that we realized was a lawyer would file a case, and he'd have a hearing in front of Judge Boyer. I'm not singling her out, just to make the example. And Judge Boyer would rule on a motion, and they didn't like it, so they'd go to Judge Levine and try to get another result later on in another motion. And we decided that for orderly business, it was important that each case be assigned. And Judge Boyer is the administrative judge. She would assign the cases to all the four judges of the civil division, and we did what we call a case management conference, and that goes out with the summons. That means that 90 days after the case is filed, the lawyers come in and we set deadlines for dispositive motions. They pick a mediator, and we set a pretrial conference. And that case remains with that judge. There's no judge shopping anymore. Mediation, of course, is a matter where it's submitted to an impartial mediator, and probably 80 to 90% of those cases are mediated successfully. The result is that we don't most cases we don't waive mediation. As a result, the pretrial conferences that we have are cases that they've mediated and they haven't been able to settle it. When I became a judge, I think there was about 2 to 3 year wait for trials. Now it's down to about a year. That helps. We also, I came up with this idea. I'm not taking credit. It was a collaborative effort, if you will, what we changed. We have what we call a status conference that happens 30 days before a trial. And at that point, we look at motions in limine to exclude evidence. We talk about potential instructions, any evidentiary problems that we have. And I came up with this idea when I talk to the lawyers. I say to them, all right, we're 30 days before trial. Is there a chance this case will settle? I know you mediated. And, that's where the rubber hits the road, because they're spending a lot of money. And I came up with this idea, and it was accepted by my fellow judges, that we would do what we call judicial settlement conferences. That is, if I have a case that they say that they can settle, I give them a choice of Judge Boyer, Judge Avery, or Judge Bobet, and we have judicial settlement conference, and I'm proud to say, because I've done them for other judges, we probably have a 95% record of. The result is cases are resolved, which is, after all, what we're supposed to do anyhow. And I'm proud of that. And I'm going to get to your question about the issues, okay? But I'm getting it in a roundabout way to tell you how cases have evolved. Judge Bobet chaired a committee, and we worked with him on revising our civil rules for the Allen Superior Court and for Circuit Court. And he worked with Judge Feltz to do that, and with our law clerks. And as a result, our civil rules were revised. Among the things that we changed were a couple. One, lawyers submit interrogatories. These are questions to be answered under oath. And the lawyers, we got feedback from the lawyers that people have multiple, like hundreds of interrogatories, so we put a limit of 50, including subparagraphs. That will streamline the discovery process. We also have a general admonition to jurors not to do investigations of their own, and usually said something like using the internet and other. Now it's pretty specific. It says don't use the internet, Facebook, LinkedIn, Twitter, Instagram, things. Some of the things I admittedly don't use myself and don't know what they are. But it's a, let's put, if you will, a 21st century admonition. Now, issues facing the court, last year we went live on Odyssey, which is a statewide case management system, and our case management is kept by the state through their computers, and it's accessible to lawyers who want to know the status of the case. They can check Odyssey. The new thing that's on the horizon is something that the state is doing, and that's e-filing. It's already done in federal court. That means that they're putting out our request for proposal for providers, that a lawyer will be able to file his pleadings electronically. His or her, should be politically correct there, electronically, and they'll be available to us electronically. I see a day soon, because I mean you have no idea how many paper files there are and how many trees died for those paper files in a clerk's office. I see a day coming when I will have, instead of the monitor behind me, it could be on my desk, I'll have a monitor right in front of me, and I will scroll through the pleadings. I won't have to handle papers and flip through. When you have a big file, you're flipping through files this big. It's very, I want to be part of that. It's not only have we changed our rules in 1970, but we have made that progress. And another thing that I see as my role is my role is not to let the lawyers run the case, but let the judge run the case. Sure, they'll do the work, but I have to, if you would, put the hoops up that they have to jump through. And I have been fortunate enough, by design, by luck or whatever, to have been on some panels in the state as well as nationally, not that I'm an expert, but on electronic discovery. And as you can well imagine, in the 21st century, in the latter part of the 20th as well, when there are big cases, particularly in federal court, for example, if there is a say a discrimination case where somebody said they were not hired because there was discrimination because of their race or gender, there are discovery motions asking for all the emails that they've done for maybe 2-3 years back, maybe back farther than they even preserve them. So what happens is general counsel, the in-house counsel, has to establish preservation methods of preserving these things. And then there are battles in federal court, mostly, although I think there are judges that have had them here, about getting that electronic discovery, and it becomes a question of proportionality. In other words, what are you seeking and what is it going to cost to get? Because by the time you get some of those discovery requests, the method of even keeping the records has changed. The physical computers that you use are different. The different methods of preserving have changed. And so we have a cottage industry of experts that testify in those matters. My children frankly, were mystified that I would be on a panel like that, because they thought that I had not even completely adapted to or learned all the intricacies of a computer and an internet and my cell phone. And I said, well, I learned, So they were proud of their father, who, was doing, at least understood the method of doing that. It's going to happen in our court as well. And one of the things I discovered, I've been on these panels, and I haven't been an integral part of it, but I've chaired a couple of continuing legal education programs for our judges on the subject and brought in experts. And one of the things when I first got on there, they said, well, how is it different in state court, Judge Levine? And I said, well, in Indiana, at least, and this is what I represented at that time, that in federal court, I said we have a case management meeting, the first hearing, the first thing we do in a case. Federal court has that as well. And but they have what they call a meet and confer requirement, and that says that before they have that initial hearing, the lawyers have to meet and confer and discuss what evidentiary problems, what discovery problems, etc. In other words, they have to get together. And I always represented, at least initially, that we don't have that in Indiana. And it's true that in our initial hearing we don't. But then I was sitting one day and I was confronted with an evidentiary problem, and the lawyers were fighting about it. It was a big case and a big battle. And I took a hard look at our trial rules. And the trial rule, lo and behold, not a revelation, maybe I should have done it sooner. It said that when you have a pretrial conference, there is a meet and confer requirement. Now, I told you, a pretrial conference happens, it's the second big hearing that we have. And so what I have done when we have these is I have a meet and confer. I order the lawyers. I said, if we have a big battle, I set a preliminary pretrial conference on the very issue they're fighting about, and I make them meet and confer. Most of the time, those hearings go away. 2 days ago, I had 2 lawyers come in on a motion to compel discovery and a motion for sanctions, and it was apparent that they weren't playing hide the ball, but they weren't meeting. So there were 3 lawyers, 2 on one side and one on another. I said, not going to have the hearing right now. Go down in the courtroom and try to resolve this. An hour and a half later, they resolved everything. I didn't have to have a hearing. That's what a judge is supposed to do. That's the challenge, that if you're a good judge, this is what you have to do. I would like to tell you something that I learned early in life in my legal career and had to learn again. We used to have something called city court, and the judge at the time I became a lawyer was Joe Christoph, and there was a rite of passage for young lawyers that he would see on the street. Says, I want you to pro tem to act as sitting judge in city court tomorrow. And I'd say, never been a judge. And he said, you'll figure it out. So I'd been a lawyer for a few months. I knew what criminal law was. I knew what the standard was beyond a reasonable doubt. But that is where, that's one area where the rubber hits the road, as you say, and it's people's only contact made with the legal system. And you hear amazing, you know, they're misdemeanors, traffic cases, drunk driving cases, assault and battery, things like that. And, you know, quickly I learned you have to make a decision. And I enjoyed it. It was kind of a challenge the first 10 minutes, and then I got into it. And, you know, we had that interesting custom. The old city court was where the history museum is now. And somebody filed a change of judge. The next lawyer that walked in the door literally became the special judge, and they'd go in another room and hear the case. And I revisited that, if you will, my first day in practice as a lawyer, I mean as a judge. It was January 3rd, I think, 1999, and it was really snowing hard. We had a blizzard. So there I am, first day of work, there's a blizzard. And I hear on the radio, that on WOWO, that the courthouse is closed. So I'm thinking, so what? I'm going to work. So I drive down there and I find out that circuit court's closed, but the courthouse is open. And my office was being renovated. I had a small office next to small claims court. Small claims court was located on the ground floor of the courthouse then, and I assumed the bench and began hearing cases because the judge who was supposed to do it didn't show up. And the first 2 or 3 cases I had, I took under advisement. I wanted to think about what I would do. And then I began to think, you know, these people don't want to wait a week for justice. They want it then. So I realized as I sat there, you got to make a decision. You're not a mediator. You're not trying to figure out what this person wants or that person. They didn't come for you to analyze what they want. They want a decision. So I began to make decisions, boom, 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 on the bench. And I reflected afterwards about this. When I was practicing law, I took a number of hours of mediation training. I was a trained mediator. I mediated a lot of cases. And in mediation, you try to find some common ground. They teach you how to look beyond what they're saying to what they really want. That isn't the same as deciding a case. That is in opposite of deciding a case. To be a judge, you have to make those decisions. You have to be able to listen to what people say, listen to what they want, and then decide who wins and who loses. It's not an easy thing to do. It was difficult when I first began to be a judge. It's difficult now sometimes because the kind of things that go before us are highly contested, and they're looking for me to make a decision. That's not something that I learned the first day I became a judge, although I told you the first day I learned I had to do it. But you develop an ability to make demands on lawyers to help you do that. How do you do that? Well, if you have a highly contested case involving a lot of money, I tell the lawyers I want what we call proposed findings of fact and conclusions of law. And if it's important enough for you to submit to me, and I'm not a shill for my court reporter, get a transcript. And you don't have to file that until you get the transcript, and I'll give you 60 days afterwards, so that when you file your proposed findings of fact and conclusions of law, you can make reference to the actual evidence in the transcript rather than what you remember or took notes on. It's very helpful to me. And also, side benefit, I get a copy of the transcript and I can look at it as well. The other thing I tell lawyers is, unless, and I call them in, I said, unless you're putting on a dog and pony show for your clients, I don't want to hear closing arguments. I want you to file a post-trial memorandum after you've read the transcript, after you've done your findings. And it can be argumentative. I expect it to be argumentative. I expect you to argue why I should rule for you. But it will be much more cohesive than something you came up for a 10-minute off the top of your head talk. I found that very helpful. The lawyers appreciate that. That's my style. I don't do things, you know, people come in and say, well, Judge such and such did it this way. Thank you. That's not binding on me. I do it, I hate to sound like Frank Sinatra, but I do it my way. And it's gratifying to know that this is in a sense, although they're adversaries, when lawyers do that and submit it to a judge, it's a collaborative effort. They submit something to me, and of course I have to make the decision. It's a challenge, but it's one that I want to keep doing.